Hi, everybody. Thank you so much for joining us today. I am Michelle Morris from Consolidated Planning Group. I want to thank Deborah Seeley and everybody at Red Oak ISD for inviting us to present this fantastic webinar. And I especially want to thank attorney Rachel Dickison for being here and sharing all this fantastic information we're going to hear today about wills, trusts, guardianship, all the legal side of the special needs planning process and what you need to know. At Consolidated Planning Group, we do the financial side, and then we always rely on experts like Rachel to do the paperwork side and the legal side of things. So it's super important that you have both sides in place and you have your expert team and you have that foundation set up and ready to go. A couple of housekeeping items before we get started. We are in webinar mode, which means that we cannot see you or hear you, but we know you're out there. So if you have any questions or comments, please put those in the chat box. And I appreciate that some people already have. Thank you very much. Also, this webinar is being recorded. We will send you a copy of the slides and we will send you a link to this recording. All of our recordings go on to live on our YouTube channel, so feel free to check that out later. Why should you listen to us at all? Well, Consolidated Planning Group has been around for 30 years, and we focus primarily on helping families who have some individual in their life, whether it be a child or a sibling or whatever loved one is in your life, who might have some differences in terms of an intellectual or developmental disability. We are a holistic planning firm, which means, we want to look at all aspects of your financial life and help you with everything from life insurance to the special needs plan to estate planning and your retirement needs and life insurance and investments. We are licensed for all of those areas. We're also members of the Special Needs Planning Academy, and we're nationally Social Security advisors. We're national Social Security advisors. The other thing that I want to let you know is that we are located just outside of Houston, but we can serve families all across Texas and all across the United States. The things that we're going to be talking about today mainly will pertain to Texas, but if you're in a different state, feel free to reach out to us and we can still help you. People come to us for things like protection plans and thinking about how much is it going to cost to take care of my loved one for the rest of their life once I'm gone, and who will do that for me. We talk a lot about transition planning and ABLE accounts, and really we're just here to educate and advocate for families like yours, because the owner of our company has two special needs kids. And when they were diagnosed and she was going through this, especially when they were teenagers, she found that it was very confusing and there was a lot you needed to know. And even though she's a financial advisor, she didn't know all of that stuff. So we want to make it easier on you. Maybe you can know some of the important stuff ahead of time. Maybe we can help filter out some of the noise and prepare you for what is to come. Fewer than 0.1% of all the financial advisors across the United States focus on special needs planning like we do. And that's why you are in the right place. There are over 263,000 financial advisors in the United States, and only 200 of us that focus on special needs planning. My goodness, if it was just 2, that'd be crazy. Anyway, we think that the most important time to start your planning is now. It doesn't matter how old your child is, if they're a baby, if they've just been diagnosed, if it's a child, a teen, an adult, a young adult, an old adult, it doesn't matter. Right now is the time to start planning. The earlier you start, the more of an impact you can have over time. But we're never going to say, oh, you should have started a month ago or 3 years ago. That's never going to be helpful. So we just say now. Think about what you want for your future and what you want for your children's future, there are a lot of great educational options beyond high school. There are residential and day program options, and there are vocational options. Now, you do want to tour some of these opportunities before you sign up, and you might want to sign up early because there could be waiting lists. And then the last piece of advice before I let Rachel take over is just don't automatically assume that a sibling is going to want to or be able to step in to take care of your loved one when you're gone. That can create some tension, and we want them to have a good, loving relationship, not a resentful or obligatory one. So we have with us today Rachel Dickison from Weeks Law Firm. And Rachel, I will run the slides for you. I'll keep an eye on the chat box. Again, if you have any questions, please put them in the chat box. And please remember that, yes, this is being recorded and you will receive slides later on today. Rachel.
Wonderful. I'm going to go ahead and go on to the next slide. So I just want to give a brief introduction about who I am and kind of what we do, and then I'll get started on the presentation today. So hello, everyone. It's a wonderful opportunity to speak to you guys today. So my name is Rachel Dickison, as I was introduced, but I primarily do special needs planning, which includes special needs trusts, estate planning, probate, and guardianship. So there's a lot of different things that impact families with special needs. I'm going to try and give you an overview of what those most important issues are today. And then we can try and get some questions at the end for everything else. Just so you know, if your question's very specific, I might not be able to answer it. I want to try and get the general questions now, but we'd be happy to talk to you if you have any questions. All right, so let's get started. So we're talking about a variety of topics today, as you can see, but we're going to start off talking about what estate planning is and why that's important. And then we're going to talk about special needs trusts and why that's important to you as a special needs parent. And then we're going to talk about guardianship, what that actually means, and if your child actually needs a guardianship. So a lot of topics to cover, but we'll get it all done. All right. So estate planning. So you might have heard of estate planning before, but you don't really know what is an estate planning attorney. What do they do? So our goal is to help you so you can control and protect your property after you pass away. So setting up that plan to make sure that you have exactly what you want done for you. An important part of this is also planning for it not just after your death, but if you become incapacitated yourself. So who do you want that person to be that takes care of you? And we also look at things like, who do you want to give your money to? How do you want to give it to them? Do you want to give it to them outright in a trust? And when is that right time to give it to them? Say, for example, you have young children, when should you give that to them? So that's an idea of what estate planning looks like. This is really important for families that have a special needs child. And we'll go over this a little bit more later, but we want to maximize the government benefits that your child can get. So estate planning and special needs trust is an excellent way to do that, to protect your assets. And we also want to look at who will be taking care of your child after you pass away. Is that going to be a sibling? Is that going to be another family member? Who is in your life is the best person for that? So it's really important if you have a child with special needs or a family member with special needs that you consider all of these things. All right, so estate planning, we're looking at all those things, but there's different things that we do in practice, different legal documents that you might need. So the first one of these you've probably heard of is a will. So this is how you dispose of your property after death. So we'll write out all of that and what you want it to look like. You may have also heard of a revocable living trust. That's another option that you could discuss. But what's probably more prevalent for you as a special needs parent is talking about special needs trusts. So I'm going to cover that and why you would want them, but just a little preview for you. A special needs trust allows you to maximize your government benefits for your child. So you'll still, your child will still be able to have their government benefits while still having assets left to them as part of their inheritance. So we'll talk a little bit about how that actually works in a minute. Another thing that you want to consider is designating your guardian and designating who you want your child's guardian to be. So this is looking at who do you want to take care of yourself if you become incapacitated, or who do you want to take care of your child after you pass away? So these are very important legal documents, especially if your child's under guardianship. Now, another thing that we look at and consider is your beneficiary designations. So not everything that you own will go through a will. Sometimes things like 401ks, retirement accounts, and life insurance will actually go through what we call beneficiary designations. So we'll also look at that and see, can those assets go to that individual outright without going through the will and a formal probate process? Or do we want to have it where it kind of goes into the estate plan itself? We also want to make sure that you're coordinating with your other family members, especially if you have a special needs child. We don't want to have any assets go to that special needs child outright that are not in trust. So you want to coordinate with those family members to make sure it goes into their special needs trust. Another thing that we recommend for everyone, not just special needs families, is powers of attorney. And these are people that can help you plan for your own incapacity. And you can have someone to help you with your bank accounts and things like that. So it's very beneficial to have all of that. All right, so now we're going to talk a little bit about government benefits. Bear with me, it's a little dry, but it's necessary so you understand why a special needs trust is beneficial for you. So lots of different government programs are available for individuals with disabilities, but these are the ones that are the most common and the ones that you'll run into the most. So Supplemental Security Income, or SSI, is one of the main programs for individuals with disabilities. You, in 2024, will receive $943 per month for food and shelter. This amount may be reduced, and we'll talk about that in a minute, but that's the maximum amount you can receive from SSI. Also, an individual with disabilities might also receive Medicaid. And this is wonderful healthcare, good to have a foundation for that. You may have also heard of Medicaid waiver programs. So these provide assistance that are not provided in Medicaid. They can be different things like attendant care, respite, therapy, residential, or any supplies. For example, nursing is one thing that you could have. You could also have diapers. That's a main one that we see a lot with supplies for 24, whenever someone has 24-hour care. All right, next slide, please.
Too many. There you go.
So the eligibility requirements for SSI and Medicaid are based on two main factors. So one, it requires a disability determination from the Social Security Administration. And then it also requires low income and limited resources, which we'll talk about in a minute. The Medicaid waiver programs all have different requirements. So it's important to note if you're going to an estate planning attorney or special needs planning attorney, you want to note which Medicaid waiver list you're on or which ones we're planning for, so we can make sure that we're meeting those requirements. Next slide, please. So I talked about low income and resources. For SSI and Medicaid, an individual has to have per month less than $2,000 in resources and less than $2,000 in monthly income. But let's talk about what resources means and what income means, because it may not mean what you think it means. Next, thank you. So monthly income is the income that you have coming in every single month, but it can look like different things. So the main things that we see are food and shelter, cash, or any asset that can be converted to food and shelter. So there's different income limits depending on which program you're on. For Medicaid, it's less than $2,000. For SSI, it's a little bit lower. It's based on how much you can work, and you might be put into a different program if you can work more than this. But These assets are just things that you have to have for every single month. It's really important to note the cash that an asset that can be converted into food and shelter can impact your benefits. So there's just something to keep in mind. Now, the monthly income is something called deeming. So what this means is that while a child is under 18, their parents' assets or their caretaker's assets, for example, a grandparent, their income will be deemed to that child. So often, a lot of individuals will not be able to get SSI until after their 18th birthday. Now, something wonderful about SSI is if you receive $1 of SSI, you will automatically be eligible for Medicaid. That's wonderful, and that's something that a lot of our clients take advantage of. Next slide, please. All right, so something else, in-kind support and maintenance is income. So what this means is if someone else, such as a parent or grandparent, provides the food and shelter, there will be a reduction in the total SSI amount. So I mentioned that the SSI amount for 2024 is $943 per month. If someone is providing food and shelter, there will be a 1/3 reduction in their overall SSI amount. There are different ways that it can be increased. So just some of the brief ones, you can pay rent to the person that's providing the food and shelter. They can provide or they can pay their pro rata share. So for example, there's 3 individuals in the household, 2 parents and a child. The child can pay 1/3 of the cost for groceries, for example, to the parent that's actually providing that shelter and food, and then it will not be considered part of their income. You can also run it through an ABLE account. I'm not going to cover ABLE accounts as much this presentation, but they're a wonderful resource.
And we can help people set up ABLE accounts. They don't have to go through an attorney for those. You
Yes.
can go through a financial planner to get your ABLE account.
Yes. All right, so let's back up and talk about resources. So that was income, it's one requirement. Then we have resources, which is another requirement. So it's less than $2,000 in countable resources. This is really important. What's not counted is a home, a car, a personal item such as personal belongings, clothing, and then also 529 education plans. Now, what is counted is probably might be likely to impact you. So this is bank accounts, UTMA accounts. Those are for minors, and they start counting when the person turns 21. Also investments and real estate, that's not that one home they have. Those resources can count against them, and you have to have less than $2,000 of those. All right. Now, stepping aside from SSI and Medicaid, there's also another program we call Disabled Adult Child. So if a parent dies or they take their Social Security retirement, if that child is disabled prior to the age of 22, they can receive up to half of their parents' Social Security check. Now, the main reason that a lot of clients find this very useful is because after 2 years, they will be eligible for Medicare. And it's possible to be able to get Medicare and Medicaid at the same time. With Medicare, a lot more physicians take this program, so there's a lot more options for your child. Next slide. All right, so there's a lot of different programs. As I mentioned, they all have different eligibility requirements, and they all provide different services. Now, an important thing to note, if your child is not on the Medicaid waiver lists, you should put your child on the Medicaid waiver list as soon as possible. Now, there's different interest lists for every program, but we've been seeing that these lists are very, very long. We're talking maybe 15, 17, 20 years where you will be on the Medicare the Medicaid waiver list for different program. So it's important that you put your child on now so they can hopefully get those benefits in the future. Next slide, please. All right. Now, there are some other programs that are not needs-based, meaning that they're not based on these income and resource requirements. One of those is SSDI. So SSDI is based on the work record of that individual. We can sometimes see that with individuals that have special needs, but they're still working out in the community. They might be eligible for SSDI. And also Medicare. Medicare is not based on these income requirements. Next slide, please. All right. Now, one thing that we get asked a lot is, do I really need government benefits at this time? There are a lot of services that you can only get through Medicaid or through these Medicaid waiver programs. It's very beneficial to be eligible for these programs, even if you don't think that you might need it right now. And also, I mentioned the disabled adult child. With disabled adult child, it's beneficial if you have that disability determination now, so there's no questions later on. The other thing with this is if you're receiving government benefits, all the assets that you leave to your child through a trust, there'll be more of those assets and you can use them for different things. So it's really good to have that and keep your options open. So we're going to talk next about special needs trusts and why they're so special. All right. So special needs trusts are really beneficial for a lot of reasons. One of the main ones is that government benefits are not sufficient to take care of your special needs child. So I mentioned SSI is $943 per month. The government benefits might be a little bit higher depending on the program that you're in, but it's not a lot of money to take care of a child with all the needs that they have. So you want to have extra resources for that special needs child. You also want to make sure that you don't actually lose benefits. So let's go to the next slide and I'll talk about that. So a special needs trust is not a countable resource. So I had those list of things on the slide a couple of slides ago, like a house, a car. A special needs trust will not count towards a resource. If it's properly drafted, if it has the right provisions, and if it's correctly distributed by your trustee. And typically I would be able to cover a little bit more about that correct distribution, but I don't think we're going to have time to go over that today. Now, a special needs trust, the purpose is to supplement the government benefits, not take place of the government benefits. The results that we have from a special needs trust is that a child will be able to be taken care of more. They'll be able to live more independently, for example. Now, I mentioned that it's really important that you don't have loss of government benefits. I'll talk about this a little bit more in detail later, but if it's the trust, if, for example, a child gets the inheritance outright, they will be disqualified from government benefits. So they will have to use their entire inheritance to pay for things that the government program could have been used for. So that's what I mean when I say it's really important to have a special needs trust, because we don't want to spend down all of your things that you've saved up for your child if the government could have been paying for that and if they would have been eligible for that program. Now, we talked about how it's not a accountable resource. It's also not income to that child. So you have to do the distributions correctly, where typically this looks like it's not food and shelter, but it can depend on your case and your situation. But your trustee can distribute it correctly where it doesn't count as income towards the child. Next slide. All right. Now you might have heard this word trust, and you're wondering, what does that actually mean? So what a trust is it's putting different people that you trust in charge of money so they can make distributions for your child. And so you have people that you trust, and it's a vessel to hold your money that you want to leave to that child. It also provides an extra safety net for you because that way the money is not going directly outright to your child. say that they might be vulnerable to abuse, or they just may not understand how to make distributions of money. A trust, and putting it in that trust, will make sure that that money stays safe. Next slide, please. All right. Now, I mentioned government benefits are a main reason that a lot of people want to have a special needs trust. However, there's a lot of flexibility built into trusts. So if your child, it ends up that they're able to work, maybe they're on SSDI instead, the trust will actually operate as a typical trust. So the major difference with that is that your child will not be the trustee. So meaning they'll not control the money, but they'll be set aside so that money is safe. The trustee is going to manage assets and be able to pay for things for your child. So it just adds an extra layer of protection to make sure that they're not taken advantage of. And it's really adaptable for you and for anything that happens with your child. All right. Now, I have been mentioning a special needs trust. There's actually two different types of special needs trusts. So I call them a first party and a third party. What this means is that there are these two types of trusts are based on the money that's going into the trust. So the first type is a first party. What this means is it's created with the individual's own money. So this is the individual with special needs. It's created with their own money. How that happens typically is they were given an inheritance by their parents or grandparents outright. They could also receive this money through child support or any savings that they've built up through their work record, through their work. So it's created with that individual with disability's own money. The downside of a special or a first party special needs trust is that it has what's called a Medicaid payback provision. So this money, when it goes into trust, after that individual passes away, they will, let's go back one slide.
Oh, sorry.
No, it's okay. So the first party, after that individual passes away, they will, after that individual passes away, the money that is left over in the trust will go back to pay the Texas government for any Medicaid things that were provided during their lifetime. So what this means is that, say, for example, they're on Medicaid, they get money to pay for prescriptions, for example, or any services like the Medicaid waiver program. Any money that's left over in that trust after that individual passes away will go back to the state of Texas, and they use that money to actually pay for more people that are going through the Medicaid program. Next slide, please. Now, this is different from a third-party special needs trust, and this is typically when you hear an attorney referring to a special needs trust, this is typically what we're talking about. The reason why is that there is no Medicaid payback provision. So you get to choose who the money goes to after your child passes away. Now, instead of it being created with the individual's own money, it is created with someone else's money. So typically, this looks like the parents in their estate plan create a special needs trust, and that money from the parents goes to the child through that trust. So depending on your situation and the circumstances, we may need to do a third party or a first party. Next slide, please. All right. Now, a lot of people have a concern about how money is actually getting into the trust and how you'll be able to fund your child's care after you pass away. So one way is through a will. So we'll actually write in the will, instead of it going into your child outright, like I said, would impact them. The money would have to go into a first party special needs trust. They could be qualified for government benefits. It'll be written in that it'll go into a third party trust. Another way to fund that trust is life insurance. So a lot of parents will actually fund life insurance policies. They'll get life insurance policies on their life, and then it'll have it go to a special needs trust. Retirement accounts, I'm not going to cover this in depth, but they have a lot of benefits going to a special needs child. So retirement accounts are a great way to fund your special needs trust. There could also be a gift from someone else. So this could be maybe a gift from grandparents, for example, where it goes into that trust. And then it also could be from child support. So let's go to the next slide. All right. So for a special needs trust, what we do after there's money going into the trust, so we take it and it's kind of like a giant funnel. All of the different sources that you have for those assets are going to go into the special needs trust. So we'll put it all into one account that'll be for the trust. Next slide, please. Hey, let's talk a little bit more about child support because this is a little bit more confusing and one of the things we get frequent questions on. So child support, after the child turns 18, it's considered that child's income. Now, this is problematic because it will impact their Social Security and their Medicaid. So if you look at this, if you receive just $950 in child support, it will result in a total loss of SSI and Medicaid. This is because there's a dollar for dollar reduction in your SSI for any income that you have for that child support. So to make sure that you don't lose benefits, the divorce decree will actually can be ordered to be paid into a special needs trust. It will be a first party special needs trust because of that child support and because that child is entitled to their own income. So it's important that the divorce decree actually states that. So that's a little bit about child support. I'd be happy to answer more questions about that, probably outside this presentation, but this just so you have that and you're aware. Next slide, please. All right. Now, what happens if you don't have a special needs trust? So talked briefly about this before, but some parents understand that they cannot leave money to their special needs child outright in their own name. So sometimes they will not give them an inheritance at all. In that case, they will only be left with the SSI and the Medicaid, which is not it's not beneficial for them. It's very detrimental because they will not have money for all the basic things they need. And some other parents will leave money to them outright. Now, if that happens, the child will have a lot of money at first. They will be disqualified from SSI and Medicaid, but they'll have to spend through all of the inheritance that they have, and then they will be able to be back on SSI and Medicaid, and they'll be back on that $943 per month and the Medicaid program. So it's not very beneficial. We don't want that to happen. Another option that some parents try and do is to leave assets to other family members. So say, for example, we have two parents. We have a child with disabilities and a child that does not have disabilities. Now, the parents maybe decide that they're going to leave that money to the child without disabilities to take care of the child with disabilities. This could work really well at first, but if something happens to that child with disabilities, typically it would go to their spouse or their children, and that money that is set up for that child with disabilities typically doesn't stay with them. So the best option that you have is to have a special needs trust so that money is secured and is for your child with special needs. Next slide, please. All right. So we're going to switch gears a little bit. I know I talked a lot about special needs trusts, and you guys probably have some questions, but let's talk about guardianship first. So a lot of people are concerned about guardianship, and they may not know necessarily what it is. So let's talk about that. So typically, when a child turns 18, they reach the age of majority and they're able to take care of themselves. They'll be able to go to doctor's appointments, sign contracts, manage their own bank accounts, things like that. There's a big switch that happens. So before the child turns 18, the parents handle money, handle doctor's visits, makes choices about their education. Do they go to public school, private school? What does that look like? Parents also manage and provide housing and their food, and they pursue and manage treatments and services such as therapy. So that's something that the parent's responsibility is for. When the child turns 18, they're still going to have those obligations to make their own, they're still going to have all the obligations to make those decisions, but the young adult is the one that's responsible for that. So they have to make decisions based on their finances, education, residence, medical care. They're able to make all these contracts. For a lot of individuals with special needs, this can be problematic just because they may not understand what it means. We want to make sure that they're able to be taken care of. But sometimes young adults with special needs, they might be vulnerable to predators, and the parents aren't able to take care of them legally. So guardianship is a process where we can help with this. Thank you. For next slide, please. All right. So let's talk about when a young adult is not able to make the decisions they need to take care of themselves. Typically, courts in this process will look at if the individual is able to manage their own finances and their medical care. Or do they need assistance evaluating when making those decisions and communicating those decisions with other individuals? People that are more likely to need a guardianship are not able to make any of these decisions. They just don't understand what's happening, and they need someone to make those decisions for them. Next slide, please. So guardianship is a formal legal process that creates a court relationship that between the person that needs help and the person that's giving the help. So we're going to back up a little bit. I'm going to talk about the terms that we're going to use from here on out. So the person that needs help, so this would be the person with disabilities, is typically called the ward. The person who gives help would be called the guardian. Often this is parents, this is grandparents, siblings. It can range from who it is, but that's guardian and ward. Now, the court is the one that makes the decision on if the proposed ward is unable to manage their personal financial affairs, their medical decisions that they need to make. If the court determines that they're not able to manage any of those things, it will appoint the guardians or co-guardians, and it takes away the legal rights of that proposed ward to make decisions. So we're really looking at the daily life decisions that have to be made. Will they understand if they need to seek medical care? Will they understand what undergoing a surgery looks like, for example? Now, the guardianship process uses what we call substituted decision making. So the guardian makes the decision for the proposed ward, and that decision is final. Next slide, please. Now, in Texas and across the United States, really, there's a growing legal trend away from guardianship. It's a very serious process. So guardianship is going to take away the legal rights of that proposed ward. It'll take rights away such as the right to vote, to marry, to drive, and determine their personal residence. So this is a very serious thing. And the effect on this, especially in Texas, is that there's a much more stringent process for how guardianships are granted. For an example for you, the court requires a background check on all potential guardians. It also requires that guardians are trained for an hour on this process, and any attorney that is representing an individual in guardianships also has to attend a 6-hour training. So it's a very serious thing. Another kind of thing that's more practical is guardianship is no longer assumed if an individual has special needs. So in a lot of cases, it may be that you need to have a guardianship, but we have to look at the other options. So let's talk about those other options. Oh, sorry, we're gonna do that in a minute. So the next one is going to be, that's perfect, thank you. Yeah, we'll talk about those other options in just a minute. But let's talk about the types of guardianships first. So there's two major types. A lot of individuals that have a child with special needs are going to just need guardianship of the person, but it might be possible that you need guardianship of the estate. So guardianship of the person is when the guardian makes decisions on the medical and living arrangements for that person. So they're going to make all the decisions about the day-to-day life of the proposed ward. Something important to note about guardian of the person, it does require an annual report to the court. The reason for this is that it's a court-created relationship. So the court's the one that's supposed to monitor it because they create the relationship. And it's protection for that person that's under guardianship. There's another type of guardianship called guardianship of the estate. Their job is to handle the property and finances of a person, but it's only if that person has assets. So typically what we do is we look at what the income level of that individual is. Often the courts set a line of if they are eligible for government benefits, meaning that they don't have resources greater than $2,000, they probably don't need a guardianship of the estate. And there's other alternatives that can be used. With guardianship of the estate, there's actually additional reporting that's required by the court. So they'll need to do additional things like file an annual accounting of everything that went in and out of the estate during that time. So that just gives you an overview of when people are talking about guardianship. Typically, they're talking about guardianship of the person in this context we're talking about, but there are different types. Next slide, please. Additionally, there's also partial guardianship and total guardianship. There's also temporary guardianship. So a total guardianship means the proposed ward or the ward after the guardianship is granted retains no legal rights, none of their rights to make decisions. With partial guardianship, the proposed ward can retain specific rights. Typically, those come into play with the right to marry, to vote, to determine their personal residence, and to drive. Yeah. So those are their different rights that typically they retain. It can be different ones in this, depending on the situation. But partial guardianship would be retaining some of those rights. A total guardianship would be you're not retaining those rights. Now, a temporary guardianship is a faster process where the proposed ward or the ward needs immediate action to help them not be in harm anymore. So this is something we don't see as often, but this is for a very limited period of time. We're talking maybe 14 days to, you can expend it a little bit longer, but this is something that's in place if the proposed ward needs to be protected immediately. Next slide, please. Okay, so I mentioned that there's other alternatives to guardianship, and we'll talk about what option is right for you. So less restrictive alternatives are something that's required by the state of Texas. You have to look at these to see, is this a good option for me, or is guardianship really what we want to do? Guardianship is more viewed as a last resort, but a lot of families with an individual with special needs, they need to have that guardianship. So let's look at what that means. Guardianship of the person, some alternatives could be a medical power of attorney or a HIPAA release. So these are making medical decisions if that person is not able to make medical decisions themselves. There also could be a durable power of attorney. This is financial decisions and their financial decision making. You can also have something called a supported decision-making agreement, which I'm going to talk about more in a second. But this requires that the individual is able to understand what that document means and what it says. So that's kind of what we're looking at with guardianship of the person. Now, guardianship of the estate. There's different things that can be used for this. The most common is representative payee for the Social Security check. This is why if you're receiving government benefits and you're underneath that threshold, typically you have a representative payee that's able to receive the money and spend it for you. or help you manage that process. So that's what a representative payee is, a great alternative that we see a lot of families use, why we don't do a lot of guardianship of the estate. Another one could be a special needs trust. So all of those assets that they have, if they're managed by a trustee in a special needs trust, they don't need a guardianship of the estate. Another option is a joint checking account where the parents and that child have a checking account that they can both access and monitor. Another one that's not listed here is an ABLE account. So those are another good option. Next slide, please. All right. So supported decision-making is a great alternative for guardianship of the person. Texas was actually the first state to enact this alternative to guardianship. But if you want more information and you're out of state, you can see a little bit more there. But with a supported decision-making agreement, there is a supporter and there's a decider. So the person with the disability is the decider, and the person that's helping support them is a supporter. Typically, we see that it's a parent or a trusted sibling, something like that. So the person with the disability or the decider will choose someone they trust. The supporter's job is to gather up facts and information for the decider. So they're there to help them understand any options that they have, the risks and benefits of a decision that they're making. They also can help them make decisions on specific things like where to live and with who to live. What supports and services do I need? What kind of medical care do I need? Do I need that surgery, or what's the downside of this? And where do I want to work? That's another thing that we commonly see. Now, the supporter communicates the decisions to the other individuals. However, the decider is the one that makes all of those decisions. So they make the decisions, supporters are the ones that make it happen. So there's a written agreement, it's a state form, and it's signed and notarized by the person with disabilities, the decider, and the supporter. And the person that's the decider, they must understand the benefits, the consequences, and the risks of any decision that they're going to make. So it's a good option, but it's not for everyone. You have to understand those decisions that you're making. And something else important to note, there can be multiple supporters. So you can have two individuals on that, such as parents. You can also have multiple supported decision-making agreements. Recently, I did one where we had two parents sign a supported decision-making agreement with a decider. And then we also had a sibling that signed a supported decision-making agreement with that decider, because they had a variety of people that were able to help them with their medical care and their financial situation. So they wanted to have multiple people. Next slide, please. So with the supported decision-making agreement, it's wonderful because the child's rights are not curtailed. So they don't lose those rights that they have. They're able to make their own decisions. And it's about support, not control. So the decider is the one that's in charge of making those decisions, and the parents or the parents or the supporters are there to just support. They're there to help help them understand those decisions. And there's a lot of freedom in that and independence. The disadvantages of supported decision making is that there's no court supervision. So like I said, it can be signed by anyone. This means that the individual with disabilities might be more subject to any negative or bad influence. So there's a potential for conflict or for abuse for that child. You also can't force someone to honor it. There is a statute that says you should honor it, but not a lot of people know about supported decision making. And so it's harder to use these in practice. And it may not provide enough care and protection for you. Next slide, please. All right, so we're going to talk a little bit about the duties and powers of guardians, and then I'm going to talk about if guardianship is the right option for you, and then we'll be back to questions. All right, so guardian of the person, they look at ensuring the ward's needs are met. They will determine where that person lives. manage medical care, treatment, where they work, educational choices, if they're going to go to a job training program, or if they're maybe want to go to college or another college program. They also determine who has access to the proposed ward. That's guardian of the person. Guardian of the estate handles and manages money, investments, property. They use money to help pay for the child's bills. They can also sell property if the court approves it, and they enter into contracts on behalf of the proposed ward. They can also sue on behalf of the person under guardianship. Next slide, please. So a guardianship has some things that they cannot do, either type of guardian. So they cannot place the ward in a mental facility. This is a separate proceeding that's done. They also cannot force them to take their medication. That's not something you have the authority to do. A guardian also does not have responsibilities for the illegal acts of the ward. So if the ward does something illegal, the guardian doesn't have to take responsibility for that. But a guardian also can't protect a ward from their own bad choices. So if they go out and they're going to make bad decisions, you can't fix that with a guardianship. And a guardian also is not required to pay the ward's debtors. So they don't, if a ward has debts, the guardian doesn't have to use their own money to pay for it. Next slide, please. So guardian of the person, it renews every single year, and there's an annual report that's required by the court. It's something that's filled out. You do not need to have an attorney for this, so it renews every year automatically. The guardian of the estate, however, requires an attorney for all the different filings they need. So they have to file an inventory of all the assets that the ward owns. They also have to have an investment plan of how that estate is going to make money. They have a bank account they need to provide records for, and they ask permission through an annual plan on money to spend, anything that they want to buy or sell, and it requires an annual accounting. Next slide, please. So then you're trying to consider, should I have guardianship or should I have one of these less restrictive alternatives? We looked at a variety of factors. So one of those is guardianship necessary to care for and protect the individual? Can they make decisions that are in their own best interest? Do they understand what that means? Can they provide their own food and shelter if they're acting independently? And are they vulnerable to being taken advantage of? So you want to consider all these things. Next slide, please. If you want some more specific questions, this is a great slide to look at of different things that you can evaluate. And this is one of the things when you're sitting in a consultation with a guardianship attorney, we're going to talk to you about. What are these things? What's the best option in your situation? Because every child with disabilities, every person that we're considering for guardianship, everyone's different. So what works for one family may not work for you. And so we're going to look at all of those different things. But this is a great slide for kind of some of those things you might want to consider. Next slide. Thank you. All right. So the other thing that a court will look at is, are there alternatives to meet the needs? So those less restrictive alternatives that we mentioned, the court is going to look at that when they're making their decision. And you also want to ask yourself, have I done everything possible to make sure that this person maintains their independence and their decision-making before I file for guardianship? We have some clients that try powers of attorney first and then see if it works, and then they do guardianship. So that is an option if you think that might be good for your family. Next slide, please. All right. Now, something that we get asked all the time is, when do I actually need to start this process? When does this actually matter? So when do I need to create the special needs trust? This is very open. It's up to you. Really, we recommend it before death or disability. So you want to make sure before you pass away and your assets go outright to your child, or before you become incapacitated yourself and are not able to make these decisions about your estate planning, you want to have it done before then. Unfortunately, we are not all knowing, so we don't know when that's going to happen. So we recommend, come in as soon as you're comfortable. This is a lot to talk about, like with you passing away and planning for your child. We get that, we understand that. So whenever you're comfortable and whenever you're ready, it's a good time to start a special needs trust. It's not related at all to guardianship. That's a completely separate thing. We sometimes do them at the same time, but we can do them at a different time. So guardianship in particular, it can happen after the 18th birthday, but the earliest that we can start this process is 6 months before the 18th birthday. So the actual hearing for determining guardianship cannot happen until on or after the 18th birthday, because that's when they receive their legal rights for their being an adult. So we can't have the hearing until after that. Next slide, please. So just as a recap for everything, what is the result of wise planning and planning for your future? You'll have a financial plan to help pay for your child's care after you pass away. You'll have people and a support team in place. You'll also be able to leave instructions for their care and what you do that maybe no one else knows. You will also be able to retain the eligibility for government benefits in these programs. And the overall goal of all of this is to maintain the well-being of your child and have them so that they have a more fulfilling life. And then I'm ready for any questions that y'all have. I know it was a lot, and I'll try and get as much as I can, but let's do some questions.
It was, but you did so good. And a lot of these questions have already kind of been answered. I think, but we did talk. What's the difference between a special needs trust and a supplemental trust? Is that the same?
Great question. So it depends on which attorney you're talking to. Practically, they're both special needs trusts. So we just call them different things. At our firm, to distinguish between first party trusts and third party trusts, we call first party trusts special needs trusts and third party trusts supplemental needs trusts. But they're the same kind of goal and benefit. So we're calling them special needs trusts for this presentation. At our firm, at our practice, we typically call them supplemental needs trusts. But they're essentially the same thing.
Perfect. Now you kind of said that supported decision making doesn't really have to be taken by everybody. So if it's not going to work for them, they're going to need to get guardianship.
Yes, it depends on the situation. We found that a lot of education institutions, especially if you're over 18 and you're in high school, a lot of those individuals will take the supported decision making. They're very well educated about this process. It's the general public. So, for example, banks can have problems. We can have issues with supported decision making. It says that they're supposed to follow it in the law, but there's a lot of efforts to educate so that people actually understand what this is. And so, yes, it may not work, but that's one of the best benefits of guardianship now is that if you try a less restrictive alternative and it doesn't work, it's not going to hurt you when you apply for guardianship. You don't have to do it at 18. You can do it later and say, we tried all these things. This is all the problems that we encountered, and it actually helps you in your guardianship case. So that's something to note.
That's very true. So before we go on with the rest of the questions, I just want to say, everybody who is here, you'll get these slides. So you'll be able to have this slide with Rachel's information. And I just want to let you know that we're also going to send you a link to all of our upcoming webinars so you can register for them in advance. And even if you can't make it, we will email the stuff to you, the slides and the link to the recording. This is our team. We will reach out to you to see if you would like to schedule an appointment with us. You could also use this QR code to do that, or call the office or email us. This is a free initial Zoom consultation. We want to answer your questions. We want to learn about who you are, and we want to tell you how we work and what we charge. There is no obligation for this Zoom consultation. Even if you're sure that you're not going to use us, at least you have a chance to chat with us and pick our brain a little bit. and get information that you might need. So please go ahead and sign up for your free consultation. Okay, so there's a couple questions here about the waiver, the Medicaid waiver income limits. And does SSI or even SSDI affect those limits
For Medicaid waiver programs?
for the waivers? Yes.
Okay. It really depends on the actual Medicaid waiver itself. Typically, I'll just say generally it's above the resource limits that I had mentioned before. Typically it's above, so it'll allow more for the Social Security or supplemental security income or SSDI, SSI. It'll typically be above that, but it really depends on what program you have. I wish I could answer your question more, but you would look up those specific programs.
And a child can have both a first party and third party trust.
That's correct.
Are you aware of a provision that allows a parent to transfer their own assets to the special needs trust so that their assets are not subject to that Medicaid look back?
Okay, let me recap on that. So
Yeah,
if it's a parent leaving assets to their child, that would be a third party trust. So there wouldn't be a Medicaid payback provision. Now say that we get an inheritance. So parents pass away, the inheritance goes out right. You can actually modify it in the probate court proceedings where it goes into a third party trust and you don't have that Medicaid payback. But if it is going to them outright and we didn't catch it in that probate process, it would be a first party or child support. We can't really change that. And for the most part with special needs planning, you typically see that there's no Medicaid payback provision, but there's just certain circumstances where it would apply.
all right. And we are over the time. So I just want you to speak on one more thing, and that is, what does all of this cost generally?
Yeah. So it depends on what you're doing. Generally it's expensive. Just so you know, we kind of give our costs a general idea of costs because we want families to be able to save up for it. I would say we typically do the special needs trusts and the will package. So generally for that, it's around $5,000, $6,000. It's a lot of money, and we know that. But we think that you should have the entire plan put together and not just do the trust by itself. So we understand it's a lot, but we want to make sure that you don't have to worry ever again about that. So I would say around then, if you want to call our office for your particular situation, if you're single, you're married, whatever that is, we can give you a quote on what our office charges. There's different firms that charge different things, so it really just depends.
Thank you so much, Rachel, for being here with us today, and for everybody who attended. I hope that you got some very valuable information out of this. If we didn't get to your question, I'm so sorry, but we're out of time. But please, you can reach out to me or you can reach out to Rachel. I'm sure we're both very willing to help you. You have all the contact info you need. You will receive these slides and a link to the recording in your email later on today. Feel free to reach out to either one of us. So thank you very much. Rachel's contact info is in the slides. You will get that, and you will get the email with her contact info later on today. Okay. Have a fantastic day, everybody. Thank you. Thank you. Thank you. Bye-bye.